Good day. Welcome to our video presentation on privacy legislation in occupational therapy practice. My name is Sandra Carter, and I manage the practice program here at the college.
And my name is Diane C., and I work with Sandra on the practice resource team.
Today's session is about helping occupational therapists navigate our new practice guidance document on privacy legislation and discuss how it applies to your practice. Our aim is that this presentation will be helpful to you as we partner together, striving towards quality practice in the interest of public protection. Next slide, please. First, we will start with the land acknowledgement, acknowledging the land that we are so privileged to live and work on. We recognize that we work and live on traditional lands and territories of Indigenous peoples. This includes the traditional territories of the Mississauga, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people. Today, the province of Ontario is home to many diverse First Nations, Inuit, and Métis peoples, from the Cree in the northern reaches to the Delaware in the south. We acknowledge that we are tasked with sharing, respecting, and valuing the land as a source of life for us all. Next slide, please. We encourage you to take a few moments to acknowledge the lands where you are viewing this presentation from. To learn more, you can visit the link on this slide, Whose Land, to learn more. Next slide, please. Here's an overview of today's presentation. We will discuss why privacy matters. We will have a brief overview of 3 privacy legislations. We will discuss privacy in your practice. And we will also answer some common questions we receive in the Practice Resource Service. Next slide, please. Today's presentation is an overview of our practice guidance document on privacy. This is not legal advice, nor is it intended to replace any legal advice you may have obtained. I will now turn it over to Diane.
Thank you, Sandra. We are talking about this topic today because the college has a mandate and commitment to public protection. The college's role is to oversee the practice of occupational therapists in Ontario by putting in place regulatory practices and engaging OTs in the delivery of safe and effective occupational therapy services. One of the ways we do this is by providing practice resources. The college recently published a guidance document to help OTs understand the legislation and their professional responsibilities in protecting client privacy. We encourage you to take a few moments after this presentation to review the document, which you can find on the college's website. Next slide. Privacy matters because it is a fundamental right of every Ontarian. In order to protect that right, Ontario public institutions are required by law to follow rules when collecting, using, and disclosing an individual's personal information and personal health information. Understanding the privacy laws that apply to your OT practice is important in helping clients know and understand who has access to their information and how it is collected, used, and disclosed to others. This allows clients to have the necessary information to make decisions about their healthcare service. Next slide. Today, you will hear about 3 privacy laws that OTs work under. While all 3 laws are distinct, the core principles in all of them are similar in that they all address the importance of securing client personal information and personal health information, protecting it against unauthorized access, use, or theft, managing requests to access or make changes to the record, and having processes in place for privacy breaches. Next slide. So, how do OTs apply privacy legislation? Well, the rules that OTs follow are not only guided by the legislation, but also by the college's standards of practice and any organizational or employer policies in their workplace. You will notice that many of the requirements set out in the standard for consent or the standard for record keeping, for example, are based on legislative requirements. There may also be confidentiality and privacy responsibilities based on the organizational policies in your work setting. The province has an Information and Privacy Commissioner, also known as the IPC. The IPC provides guidance and oversight related to compliance with privacy legislation, and they also investigate privacy complaints and breaches. Their guidance is often directed by decisions from the courts. So when OTs are thinking about the rules they need to follow, they need to consider all of these sources. Next slide. And over to Sandra.
Thanks, Diane. The three privacy legislations we will address today are the Personal Health Information Protection Act, PHIPAA, Personal Information Protection and Electronics Documents Act, PIPEDA, and the Federal Privacy Act. Each one will be referred to by its acronym throughout the rest of this presentation. OTs ask, what privacy laws apply to my practice? The privacy laws that applies will depend on 2 points. One, whether the services provided are considered healthcare or non-healthcare. When we speak of non-healthcare services, these are services that may be rendered for commercial business purposes. For example, independent evaluations for a third party, such as an insurance company. And 2, the type of organization through which the services are funded or delivered. For example, by the municipal, provincial, or federal governments, or services provided to Indigenous communities. Next slide, please. PHIPAA. Occupational therapists should be familiar with the Ontario privacy legislation. This legislation governs the collection, use, and disclosure of personal health information. What is personal health information? It is information about an individual's physical or mental health, or the health history of their family. It can be information about providing health care to an individual, including the identification of who their healthcare provider is. For example, an OT providing service to a client, and that is known, that is personal health information. Information about home and community care services to a client by a provider in healthcare or from the Ontario Health Team. It can be payments or eligibility for health coverage, or it can be as simple as the individual's health record. For more details on what's considered personal health information, you can refer to our privacy guidance at a later time. So what are the legal obligations for OTs under PHIPAA? PHIPAA outlines the roles and responsibilities of a health information custodian, the HIC, or the agent of the HIC. We will go into more detail about these roles on the next slide. What are the expectations around consent? OT should understand that the requirements for obtaining valid consent under this legislation is important. This includes obtaining consent for clients before using, collecting, and sharing their health information. Under this privacy law, disclosing personal information is done only when permitted by the client. The exception is Disclosure is permitted if required by law. An example would be disclosing personal health information for the purpose of an investigation under the Regulated Health Professions Act. What are the requirements around confidentiality and security? OTs are expected to take appropriate and reasonable measures to safeguard the personal health information in their custody or control by ensuring the personal health information is kept secure and confidential. Next slide, please. Are you the health information custodian or the agent? You may be surprised to know that most OTs are not sure. The health information custodian is an individual or an organization that has custody or control of personal health information. Essentially, HICs are responsible for managing the health record of the client, storing the record for the required retention period, developing the processes and procedures for individual to access their records, and develop privacy policies accessible to the public upon request. The agent, on the other hand, works on behalf of the HIC and must follow the processes set out by the HIC. An agent is responsible to return all personal health information to the HIC upon completion of their duties. The role of the HIC or agent needs to be established before you start working with your clients, especially in practice settings where there may be multiple custodians. When starting a new position, ask the question, who will be responsible for managing the client record? Who has the control and custody of the record? If you are a private or independent practice OT, you are likely the HIC. Some other responsibilities of the HIC are to take reasonable steps to ensure that personal health information is protected against theft, loss, unauthorized use, and disclosure. You're responsible for any modifications or destruction of the record. And in today's world, this can include the prevention of cyber attacks. Another role and responsibility is to make health records available to clients on request, to respond to correction requests, and develop and implement policies and procedures for responding to consent directives, including the appropriate management of restricted information. You will hear more about the consent directives later. The HIC is also responsible to have policies to address privacy and report breaches to the appropriate information and privacy commissioner. They are also responsible to ensure all staff, students, and contracted agents are trained to comply with the privacy legislation PHIPAA, and that all vendors and community partners are aware of the appropriate privacy expectations. The agent, on the other hand, is responsible to follow the HIC policies for storing, safeguarding, retention, and destruction, corrections, and access of the health record. An agent must notify the HIC if personal health information that they are handling is stolen, lost, or accessed by an unauthorized person. They're also able to receive a request for access to or disclosure of personal health information and follow the processes for the HIC. And they are also able to receive the request for corrections to the health record held by the custodian. And they also can receive consent directives. And again, we will talk more about that in subsequent slides. Next slide, please. PIPEDA is a federal legislation that governs, similar to PHIPAA, the collection, use, and disclosure of personal information collected during the course of commercial activities. What is personal information? Under PIPEDA, personal information includes any identifying information about an individual that has been communicated or reported. This includes information such as age, name, ID numbers, income, ethnic origin, blood type, any opinions or comments, social status. It can be any disciplinary action, employee files, credit records, loan records, etc. In occupational therapy practice, PIPEDA may apply to fee-for-service insurance or medical legal assessments, which are carried out to help an insurer, employer, or third party determine entitlement to benefits or coverage, rather than for therapeutic benefit or the purpose of providing clients with healthcare services. Many of the privacy requirements under PIPEDA are substantially similar to those in PHIPAA. So what are the expectations around consent under PIPEDA? This includes obtaining consent for clients before using, collecting, and sharing their personal information. And what are the expectations around safeguards and accountability? OTs are expected to take appropriate and reasonable measures to safeguard the personal information in their custody or control by ensuring the personal information is kept secure and confidential. Next slide, please. The Federal Privacy Act. The Privacy Act is federal legislation that applies to how the Canadian government and other federal agencies collect, use, and disclose personal information. The Privacy Act applies to occupational therapy practice when occupational therapists work for or contract services to federal agencies such as Veterans Affairs, Corrections Canada, Canada Post. The Act may also apply to services funded through the federal government and to services provided to First Nations people who live on federal reserves. The Privacy Act defines personal information as any recorded information about an identifiable individual, including age, color, marital status, origin, race, religion, education, medical, employment, criminal history, details of financial transactions, any assigned identifying number and symbol, address or fingerprint, social insurance number. And if you want an exhaustive list, you can also refer to our privacy guidance document. Our privacy document also outlines the important areas of the Privacy Act around access and correction. OTs providing services under this privacy legislation must be aware of the policies and procedures of the federal institutions they are providing services to around their collection, use, and disclosure, retention, right of access of personal information, and the right to corrections. OTs must understand their accountabilities around safeguarding and protecting the information and be aware of any additional federal laws that may apply. Next slide, please. Services delivered to Indigenous communities or with Indigenous clients may be subject to additional laws, traditions, or rules applicable to this client population. OTs are encouraged to review the First Nations principles published by the First Nations Information Governance Committee. This document speaks to the principles of ownership. This principle speaks to the understanding of the community or group that they own the information collectively in the same way that an individual owns his or her personal information. Control and management of processes that impact them. Access, that First Nations must have access to the information and data about themselves and their communities, regardless of where that information is held. And possession or stewardship, the physical control of the data. For more information about this resource, a link is included in the additional resources slide at the end. Next slide, please. So how do you know which law applies to your practice? Next slide, please. Most OTs fall under PHIPAA, privacy legislation. We recognize that some OTs practice setting may fall under PIPEDA or the Privacy Act. The courts have stated that rules for collecting, using, and disclosing and safeguarding client information under PHIPAA and PIPEDA are similar. This means that in many circumstances, the provincial law PHIPAA applies if you are providing healthcare services instead of the federal law. Determining which law applies sometimes must be done on a case-by-case basis. Essentially, an OT must be able to speak to the privacy legislation they are following for their practice. So choose the most appropriate privacy legislation. Within the guidance document, you will have some practice examples, and they will be discussed a little bit more further on in the presentation. Diane will talk about applying privacy legislation to practice in the next few slides.
Thank you, Sandra. So now that we have that overview of all the legislation, it's time to tie this all together. An OT's professional responsibilities related to privacy come from a combination of the legislation, the standards, and their organizational policies and procedures. So the first step is knowing the privacy law that applies to your practice setting. The legislation is where our responsibilities under the standards of practice and competencies stem from and then continually revolve and intersect on an ongoing basis. For example, the standard for consent and standard for record keeping outline the requirements for obtaining consent for the collection, use, and disclosure of the client's personal health information, how it then gets documented into the record, and then how the record is managed and stored. Clients can request access and correction to their information, so OTs need to know what the organizational processes are to facilitate that for a client. OTs must put in place safeguards to protect client personal health information. And if there are privacy breaches, OTs need to know what the processes are to manage these. So let's first talk a bit more about consent. Next slide. Regardless which privacy legislation you are working under, an OT is generally required to obtain consent to collect, use, or disclose personal health information about a client, unless there is a legal exception. An example of an exception would be filing a mandatory report to the Children's Aid Society if there's a child at risk of harm and in need of protection. An OT does not require consent to file this report and share client personal health information. Generally, though, OTs are required to obtain consent, and there are two types of consent: express and implied. Both of these terms are actually not defined in legislation, but it is generally accepted that express consent means consent that has been clearly and unmistakably given by the client, either verbally or in writing, to collect, use, or disclose their personal health information. Implied consent is when it is reasonable to assume that the client already knows the purpose of the collection, use, or disclosure of information for the provision of healthcare, and so their given consent is implied. Next slide. OTs are probably most familiar with implied consent in the context of circle of care. Circle of care is also not a term defined in legislation, but it is understood to be situations where OTs, as either HICs or agents, can assume they have implied consent to collect, use, and disclose information to another HIC or agent for the purpose of providing healthcare. The key elements being that the information is for the purpose of providing healthcare, and that the information is being disclosed from one custodian or agent to another custodian or agent, and that the client has not expressly withheld or withdrawn their consent. Next slide, thanks. When it comes to circle of care, here are some questions that you can ask about your own practice. Who is considered circle of care in your practice setting? Who do you have implied consent to share information with? These may differ depending on where you work. So it's important to ask, is it only those individuals within your immediate team or within your organization? What about past healthcare providers from another organization? Does it extend to others that we work with, such as those in schools, occupational health departments, or how about equipment vendors? Ensure that you are familiar with any organizational policies or processes for your practice setting, or develop policies if you have a private practice. Some organizations have their own privacy officers and a legal department that you may be able to consult. If you are an independent practitioner, you can always seek your own legal consultation. Next slide. When a client does not provide consent to disclose their personal health information, this is referred to as providing a consent directive, or commonly called lockbox. Again, the term lockbox is not defined in the legislation, but it is generally understood as the client withholding or withdrawing their consent, and therefore their personal health information is placed in a lockbox. Next slide. It is important to first clarify that a client cannot ask the OT to not record the information, as clinical documentation is a legal requirement. However, a client can direct that certain information or part of their file not be shared with another health provider. This process is referred to as a client placing their personal health information into a lockbox by expressly withholding or withdrawing consent. If the OT believes, however, that the other health provider needs the locked information to provide necessary care, then the OT must advise the receiving health provider that the locked information exists. Next slide, please. To be clear, the receiving healthcare provider can only be notified that there is locked information, but not be provided the information itself. That healthcare provider would then need to approach the client to seek express consent in order to access that locked information. An OT can only disclose personal health information about a client without consent if the OT believes on reasonable grounds that the disclosure is necessary for the purpose of eliminating or reducing a significant risk of serious bodily harm to the client or others. Next slide, please. For your own practice, some questions to reflect on are, when can a client place a lockbox on their information? Are there unique scenarios in my practice area where this may happen? What is the documentation required for lockbox? Is there a system or procedure to store this locked information in my practice setting? And how should I respond if another healthcare provider asks me about this locked information? Again, it is important to check if your organization has policies and procedures for documenting and securing lockbox information. If you have your own practice, you may need to develop these policies to ensure that there is a consistent process in place. Next slide, please. So do you know your role in protecting client privacy? We know there's a lot of information out there, so we have created a cheat sheet. Next slide. Next slide, please. Thank you. The appendix in the guidance document. Oh, we're going to go back one more slide. Thank you. The appendix in the guidance document allows you to compare the 3 privacy laws all in one table. As you can see, the table breaks it down based on the type of information, applicable parties, practice examples, and the scope of the legislation. As you can see, the scope between all 3 laws are actually quite similar, all speaking to the collection, use, and disclosure of information, retention and disposal, the safeguarding of information, and the right of access and correction. Next slide, please. As you scroll down the table, you will see the similarities and differences between the 3 laws with regards to consent and retention and destruction. For the retention of records, both PHIPAA and PIPEDA don't have prescribed retention periods. OTs are expected to follow the college's standard for record keeping, which states that records are to be maintained for at least 10 years after the date of the last entry, or 10 years after the client reached or would have reached 18 years of age. OTs should be aware that there may be organizational policies that go beyond the college's requirements. For example, records may need to be maintained longer than 10 years if there is reason to believe that the health information will be needed for a valid purpose, such as for a legal proceeding in the future. Next slide, please. And as you scroll down to the end of the table, you will see a comparison of the expectations for access and correction, maintaining current contact information, and reporting privacy breaches. We hope that this cheat sheet will be a handy reference for occupational therapists. Next slide, please. The tips to remember really involve 3 main areas. The first one is to be in the know. So know what the rules are for privacy, which include the legislation, the standards, and any organizational policies. Collect only information that is pertinent to the healthcare service being provided, and do not release information without confirming if those individuals are authorized to receive that information. The second is to take steps to safeguard information. These include physical safeguards that we are all familiar with, such as locking offices and filing cabinets, but also technical safeguards, like logging out of computers and using secure passwords and encryption. And finally, report. Report any accidental access or privacy breaches to your management or IPC. Next slide, please. So the college has received many questions related to privacy and OT practice, and so we will now like to take some time to answer a few of the most common questions. And I'll have Sandra start us off.
Thanks, Diane. So the first question is, can I be an agent and a custodian at the same time? The answer to this question is generally no. As discussed earlier, there are specific roles and responsibilities outlined in PHIPAA for the HIC and the agent of the HIC. An OT must know their role and responsibilities up front. Let's look at an example. If there is a privacy breach that has occurred, it is the HIC who must notify the client and must report the breach to the appropriate privacy commissioner, whereas the agent's role is to notify the HIC that a privacy breach has occurred, whether the PHI, the personal health information, has been lost or has been disclosed to an unauthorized individual. So as you can see from that example, there are specific roles that an agent and a HIC have under the privacy legislation. Next question.
So the next question is, am I allowed to release personal health information if it's being used for broader purposes? Is consent required from clients? There are usually other pieces of legislation that govern broader processes. For example, activities such as quality improvement research or audits conducted by the Canada Revenue Agency, and the college does not have jurisdiction over these processes. In these types of circumstances, the legislation that oversees these processes will supersede the college's standards of practice. Those parties who are requesting information should be able to cite the section in the legislation that gives them the authority to request and access information without client consent. As always, OTs are encouraged to seek their own legal advice when presented with these types of situations.
And question 3. In divorce situations, can I provide information about a child to both parents? And the answer here is, if we go back to the substitute decision maker hierarchy, both parents are ranked equally. In the situation of divorce-separated parents having shared custody, proactive communication and information sharing with both parents about occupational therapy service delivery is ideal where the interest of the child is prioritized. However, in situations where the communication or request between parents is unclear, it would be important to consult both parents transparently to clarify what information should be shared and how. However, in some circumstances, it may be necessary for the OT to ask about legal documentation related to custody agreements, and in that, seeking your organizational support and legal advice to understand the documentation received. We often have OTs to remember that they should remain neutral and objective in these situations, and remember that the OT role is to provide occupational therapy service to their client. And the next question is to you, Diane.
So the next question is, how do I know if my electronic record systems and virtual platforms are safe? That's a good question. The college, however, does not vet or approve digital systems. Occupational therapists can go on Ontario Health's website for their verified virtual standards. They provide information and a list of verified platforms to help healthcare providers make decisions about the virtual technology they want to use. In the end, OTs will need to do their own research and look at the terms of use and the privacy settings of their digital systems. Next slide, please.
Okay, thanks, Diane. The next question is, what are the expectations for privacy when providing virtual care in another province? OTs providing virtual services to clients in other provinces must follow Code of Standards and guidance. Clients must be aware of the province you are practicing and the college you are registered with. As part of providing services to clients in other provinces, OTs should familiarize themselves with the privacy requirements for their clients, as they will be following these provincial privacy laws. For example, OTs in Ontario have 30 days to respond to access requests. These rules may vary province to province, and we encourage OTs to seek out additional information for their clients living in other provinces. On to you, Diane.
Next question is, are there privacy considerations if using artificial intelligence or AI? Well, there are many considerations that need to be taken into account if using AI, and privacy is one of them. OTs should exercise caution if using AI, as there is still a lot we don't know about it yet. OTs should ensure that they are familiar with where information in the AI is going, how it is used, and where it is stored. It's important to understand the risks if you are needing to enter client information into any AI platform. In the end, the OT still has a responsibility to take reasonable steps to maintain client privacy.
And the final question: who is responsible for facilitating access to the record, especially if the OT is no longer working for the HIC? If a client reaches out to you about accessing their records and you are no longer working for the HIC, you still have an obligation to assist them in locating where the record is stored. You should make reasonable efforts to connect clients to the appropriate contact of the information custodian holding the record. And with that, we recognize that with each privacy question, there are many mitigating facts and also nuances to each situation. We encourage you to contact the Practice Resource Service as we are there to help. Next slide, please.
So we know there is always more to learn. So we have included a few other resources here to support that ongoing learning. This includes a link to the college's guidance document on privacy legislation and occupational therapy practice, a link to the Information and Privacy Commissioner of Ontario, which includes all of their resources and fact sheets, as well as a few other documents and even an interesting webinar from a privacy lawyer. So we hope all of these additional resources will be helpful. Next slide. And of course, as Sandra mentioned, if you have a specific practice question or situation that you would like to discuss, Sandra and I are both available to help. Feel free to reach out to us at the Practice Resource Service anytime by phone or email. Next slide. We thank you all for taking the time today. We hope this presentation has been helpful. Please stay connected to all the news and updates from the college through the monthly newsletter and through any of the social media channels. Have a wonderful day.